Now to formally start, for those of you who have just joined us, welcome to the Institute of Internal Auditors 60-minute session, Mandatory Data Breach Notification, Preparing for February 2018, presented by Lynn Nicholson. Lynn is the General Counsel in Corporate and Commercial at Holding Redlich. I'm about to pass control to Lynn. You'll be hearing more from me at the end of the session. Enjoy the session, everyone, and over to you, Lynn.
Hi. So today we're looking at an overview of the implications of mandatory data breach reporting. It's been a long time in legislation getting us here, and the legislation was passed in February this year, coming into play February next year, and there's a lot of work to be done between now and then. So what sort of work do we need to do? What do you need to be thinking about? What we're going to cover today is an overview. Basically, what does the Privacy Act regulate? So what are we looking at when we talk about a mandatory data breach? What are the current obligations under the Privacy Act? Because essentially, if you're not complying with those already, you're in a problem. And then thirdly, what are the new obligations under the mandatory data breach reporting? What do you have to do? What happens if you don't comply? And finally, what are the strategies to prepare for mandatory data breach reporting? And we spend a little bit of time on that. So to begin, I have a polling question, which is, where does the audience come from and where are you placed? And that's a relevant question because the Privacy Act 1988, Commonwealth, applies to Commonwealth government bodies. It also applies to business entities, whether they're companies, trusts, any sort of entity in the corporate world, which has annual revenue or annual turnover in excess of $3 million. So those of you from state government, and I know there'll be a few, state government or local councils, you're not covered by this Act, but what you could certainly think about is that it is best practice, and as you would know, sooner or later, where the federal government goes, the state governments will follow. So you won't learn anything that's not useful today. So our first issue is, what does the Privacy Act regulate? The Privacy Act protects interferences with privacy. Privacy is based on personal information, and it's very important to know what is personal information. Now that's defined in Section 6 of the Privacy Act. The Commissioner also has some guidelines on it, and he's recently produced in May this year a specific guideline on what is personal information. So it is generally information or an opinion, whether true or not, about an individual who is able to be identified or who, based on the information, is reasonably identifiable. So that definition is quite broad. Many people would think that you need all the elements to identify an individual for it to be personal information, but that's not the case. Generally, if you have 4 data points about someone, you can identify who they are. So if you've got my name, the business where I work, and my telephone number, that's personal information. Which brings me to another important point. There is no exemption for publicly available information. So if you take public information and put it into your system and hold it together with other information you hold about an individual, that will be treated as personal information, and if that information is subject to breach, you will be liable. So it's very broad, and one of the best strategies you can use is to say, if in doubt, treat it as if it was personal information. Now, a good example of something that's a bit questionable would be IP addresses and cookies, because the IP address of my computer is the IP address of my computer. It's not personal information about me. But if you know a few other things about that IP address, you might be able to very quickly know that that computer is my computer and know that what happens on that computer relates to me, and you might be able to associate the IP address with me. And on that basis, it is personal information. And certainly in Europe, they are now requiring, if you use cookies, that you specifically get people to consent to the use of cookies, because people need to understand that a cookie can mean personal information. So one of the important things for you to note is, if in doubt, treat it as personal information. And if you think that you can connect information in one of your information systems to other information in another information system, that together can be personal information, so you need to treat it all as personal information. The Telstra case said that information can be about an individual, so it's broader than just information that relates to me, it can be information about me. If you have any concerns, then you should go to the OAIC website, www.oaic.gov.au, and find the guide for personal information. It has a number of examples of what will and what won't. It also, really interestingly, takes into account the concept of what is personal information depends on the individual who holds that information, and what is personal information in one person's hands may not be personal information in another person's hands. That's a fairly important context, which means one size does not fit all. So then we say, well, how does the Privacy Act regulate privacy, and how does it regulate the holding of personal information? It basically looks at the information life cycle. It looks at when a business collects, holds, uses, discloses, and finally destroys or de-identifies information, and what happens at each stage of that life cycle. So this chart on the information life cycle is extracted from the OAIC and basically sets out the general rules about how you can implement privacy by design in your privacy procedures. The other key issue for organisations is to consider whether you have in place a privacy management framework. Now you might say, well, why is this important? It's important because the regulator has said that organisations, to meet the requirements of the Privacy Act, should have in place a privacy management framework. It's also important because not just the Australian regulator, but all of the privacy regulators in our region, and they met in July in Sydney recently, are focused on trust and transparency. They are focused on organisations building trust and transparency with their stakeholders, communicating to their stakeholders exactly what they are doing, and then walking the talk. And if you've been reading anything that other regulators have been putting out, they've been saying that a culture starts from the top, and so there needs to be embedded a culture of privacy. There needs to be established a robust set of processes which give effect to privacy policies and generic statements of compliance. There needs to be a process to evaluate and continually improve your privacy practices, and then an ability to enhance. So the evaluate step is really important because often it is complaints handling that gives you that opportunity to improve your processes. Let's say in a period of 1 quarter, you had 50 complaints about your privacy handling processes. If you had 50 complaints about 50 different things, then okay, you've got 50 separate problems. But if you had 50 complaints and 20 of them were about the same recurring issue, you would have to say there's a systemic problem, we need to look at that and we need to evaluate and enhance. And if you don't, and if at a later point the OAIC comes to investigate and he looks and says, did you have a privacy management framework, and you didn't, then in pursuing regulatory remedies and in looking whether a fine should be imposed, the Commissioner may well say that you did not take the time to set up a framework and therefore you should be penalised. So it's in your interests to establish a privacy management framework, even though that concept is fairly new. Now, one of the polling questions, does your organisation have a documented privacy management framework? In polls that I have done, that number has generally ranged from about 30% to about 50%. So there are a lot of organisations that have a long way to go. If you are in a government entity, you'll often be required under your constituent document and your rules to create one. If you're a corporate, there's no strict rule to require one other than the Commissioner's guidelines, but it is definitely in your interests. So before we move on to looking at mandatory data breach, one of the really important things we need to look at is what are your current obligations under the Privacy Act. Essentially, your obligations are to ensure that you can comply with the APPs, or the Australian Privacy Principles. If you don't comply with an APP and there is a breach of an APP, that is considered to be an interference with privacy, and that is then subject to penalty under the Act. And a mandatory data breach is most likely to occur, or sorry, a notifiable data breach is most likely to occur in a circumstance where you have breached one of these APPs. So I thought it was worthwhile that we run through it, and it is also really important to make sure that your existing processes address all of the issues. So to begin, APP 1, the Act requires that you have an open and transparent policy for the management of personal information. Now, for most people, that translates into a privacy policy that they have on their website. That's fine. Do you have processes and procedures that underpin that so that you actually walk the talk and do what you say you do? That is one of the tasks that you may want to take away from today. APP 2, each organisation, to the extent it's practicable, has an obligation to allow individuals to transact with it, either anonymously or under a pseudonym. So if you're a supermarket, fair enough, I should be able to come in and buy my food with cash and not have to tell you who I am, not have to use a loyalty card or be a member. But obviously if I'm providing health services, I'm an organisation that needs a few more details before I can provide you with my services. So that depends on the organisation. Now, APP 3, about collection of solicited personal information, covers a couple of things. APP 3 requires that you only collect information that is reasonably necessary for one or more of the entity's functions or activities. So each organisation needs to determine what purposes or what details, what elements of personal information are reasonably necessary for their functions or activities. And that is all you should be collecting. Privacy by design or privacy by default says you should not collect more than you reasonably need. And ideally, you should collect it from the individual that it relates to. Now, we don't have a requirement in Australia that you correct it directly, but in the EU, from May next year under the GDPR, they will have that obligation. Interestingly though, the direct solicited information comes into play in APP 5, and it also comes into play in APP 4, where if an organisation receives personal information from an individual that it did not request, it has an obligation to consider whether it can keep that information, and if so, it needs to keep it in accordance with its information policies, or whether it needs to return or destroy that information. APP 4 also says that you should notify the individual of what you're doing with that information. Most organisations have found that an onerous task and have interpreted it to mean if I then choose to communicate with that individual, I tell them how I obtain their information and I give them a copy of my collection notice. So what is a collection notice? A collection notice is set out in APP 5, and APP 5 requires that when you collect information from an individual, you tell them basically what you're going to use it for, part of being open and transparent and building trust. It is not sufficient to simply point someone to your privacy policy. That's not enough. Equally, it is not helpful and not sufficient to restate your entire privacy policy to the individual, because that is too long. What you are required to do is give them a short notice, a few sentences, which suggests the purposes for which you will use it. Now, that's fairly important because when you tell someone what you are going to use their information for, that then feeds into APP 6 on the use or disclosure of personal information. Now, APP 6 provides that an entity who holds personal information can only hold and use and disclose that information that was collected for a particular purpose, the primary purpose which they notified under APP 5, if the individual has consented to the disclosure, or if it is a secondary purpose that is related to the primary purpose, which is the purpose in the collection notice, and the individual would reasonably have expected the organisation to use it. So you can't collect for purpose A and use for purpose Q. They are far too far apart. So let me give you an example. If I joined the loyalty rewards program at Woolworths supermarket, I buy my groceries. When I sign up and give them my details, sure, I expect they'll give me special offers. They might tell me about things in the grocery shop. They might tell me about things in their liquor store that they have next door. But Woolworths, the public company, also owns a whole lot of gaming technologies and gambling businesses. I really don't expect them to tell me about that, and neither would the Office of the Australian Information Commissioner. So you need to make sure that your use and your disclosure, which would include sharing with third parties, is limited to the original purpose that you disclose to the individual in the collection notice, or a secondary purpose that is reasonably related to the first and an individual might expect to happen. And that then leads us on quite neatly into APP7 on direct marketing. So APP7 on direct marketing is new. It came in 2014. There's a lot of disclosure about what it would mean. A shorthand understanding of APP7 means that what was under the Spam Act now applies across all channels. The Privacy Act basically says you can market to an individual if they would expect you to market to them and they haven't opted out, and in each communication you have with them, you give them an opt-out. Now that opt-out is really important, because if you fail to give an opt-out and you continue to market to an individual, that then will be a breach of the APPs, and that will arguably net you a $2.1 million fine. So direct marketing under APP7, you can only market if the individual would reasonably expect you to use that information for the purposes that they had given it to you, or if it's publicly available consent information and they have not opted out. So people who have very weak opt-out systems, one of the things you need to work on between now and February next year is improving those systems. So that's direct marketing, which leads us in the segue into APP8, which is about cross-border disclosure of personal information. Now, APP8 sets out a couple of rules. It applies to Australian organisations, so those organisations located here, and it also applies to organisations elsewhere that collect information in relation to Australian individuals if they have a presence here. And it basically says that you cannot disclose information that was collected here overseas, so to another jurisdiction, unless a couple of conditions are satisfied, and one of those is under APP8 that the entity that discloses that information is certain that the entity in the other jurisdiction is subject to similar laws, and that there is a mandatory regime that would impose similar obligations on that entity so they can be enforced, or, and this is APP2 and the one under which most companies rely, is that both the entity has informed the individual that if they consent to their disclosure, their information will be sent overseas and APP 8.1 won't apply, and after being so informed, the individual consents. And that's the way most people do it. They say, we cannot guarantee that your information will be treated under the protections of the APPs if it goes overseas, but we're a multinational and we send it overseas. Therefore, it may go overseas, and we're giving you some examples and you consent. And if you don't consent, you can't deal with us. So that is pretty much how APP8 would apply. The last few are the few that relate significantly to the data breach and mandatory data breach environment. So APP10 talks about the quality of information. It says that organisations need to keep the personal information they hold accurate, up-to-date, complete and not misleading. that means you've got to spend money on data deduplication and otherwise making sure that when your systems talk to one another and share information, you don't aggregate information in a way that causes a problem or doubles up or duplicates me or changes my gender or records me incorrectly. And if I update my phone number, you need a system that expunges the old one and only keeps the new one, so you're not ringing the people that have my old number. So that's a fairly important one, and that is another cause of breach in the cases that have occurred to date, when there are old records and you contact the wrong people. APP 11, which we'll talk about, talks about the security of personal information, and there are obligations which we're going to go into. APP 12 allows individuals access to their information and reasonable access at no cost, unless the requests are frivolous. And subject to one other exception, which is fairly important, which is if the information that they're requesting is commercially sensitive information. So one of the key people who suffer those requests would be recruiters or placement organisations, where an individual goes for a job, they're unsuccessful, they're unhappy, they want to know why they didn't get the job and they want access to their file. The recruiter will often say, well, we'll give you a summary, but we're not giving you access to all of that information because it's commercially sensitive. Final one, correction of personal information. Individuals do have a right to correct their personal information if the information you hold about them is incorrect, except in the case of credit reporting, and I should say that credit reporting is its own section of the Privacy Act to which the APPs do not apply. Part 3A replaces it. But individuals do generally have a right to correct their personal information. Some of you might ask, and before the question comes up, what about the right to have information removed? So you may be aware of the European legislation, or there's a European case, and there's upcoming European legislation about the right to be forgotten, which is a right to have records expunged where they're old and they're no longer reflective, to have them deleted, at least from search engines. That there is no equivalent in Australian law. So I should let you know that one. And then, having talked through all of that, I would ask the question, the next polling question. As we've talked through those...
Sorry to cut across you, I might get you to, can you see your chat at the moment? Just double checking. I might get you to, you might want to...
my chat.
Yeah, so there is a question there from Paul Wong.
I see that question. Yep.
Oh, you got it there. Okay, then cool.
Would you like me to answer the question?
As you prefer, whether you'd like to answer the questions as you go through, or we can go straight into the polling question now.
I'm happy to do that. Maybe if we have the polling question, and then I'll answer that question.
Okay, cool. All right, I'll open the poll.
Okay. So the polling question is really, having gone through those APPs, has everyone got a website privacy policy that addresses each of them? Because what we often find is that people will think these don't apply to me, or we don't collect a lot of personal information, or we only collect business-to-business information, so we don't need to worry about this. Business-to-business information is covered. So even if you are collecting someone's business card, so if you've got my business card, my contact details, they're still covered. And a lot of people forget that, which is a slight problem. Now, while we're waiting for the results of the poll, someone has asked a question about how long you need to keep records for, and that is, I have to say, one of the most commonly asked questions in this space. The APPs say that you should only keep personal information for so long as your business needs them, and there are plenty of record retention obligations under other pieces of legislation that set out how long certain records are required to be retained, for example, financial records. Those laws relate to the records. They don't actually refer to underlying personal information. So often personal information that you have collected as a primary document, so we've got the results of the polling here. fabulous. 41% cover every APP and 56% don't, which is about what I would have expected. I would suggest if you go back to your organisation and think about whether you actually need to revisit and say, if we don't have it addressed in our privacy policy, do we actually have it addressed in our policies and procedures? So it's a question that's worth asking. But as we continue with this question about how long do we have to hold personal information and many documents get old, what are our obligations, I would suggest that if you have personal information that is kept on live systems, you move it to archive systems, or you take it to a place of storage where it is beyond use once you no longer need it. So a lot of the records that you need, like financial records, they will not extend to source documents that have original details, which are a lot like the privacy details and the personal information details. It is a hard question. Storage is cheap. People love to hold on to information, but it is, I've just clicked one ahead, I think, but it is one of the biggest risks, which takes us to the next slide, of which is one of the biggest risks, and one of them is basically security. A lot of people think about security as cyber security. I would say that cyber security is just one element of overall security, and that would be consistent with the OAIC view. The Commissioner has issued in January 2015 a document, a guide to securing personal information, which sets out what the Commissioner considers are the reasonable steps to securing information, which are those necessary to protect it from misuse, interference, loss, unauthorised access or disclosure. Now this goes directly to what is a breach, because Section 13 of the Privacy Act says that a breach is an interference with privacy, and an interference with privacy is often taken to be a breach of the APP. So if you have breached APP 11 in relation to security because you have not taken reasonable steps, then you are at risk of a fine. Penalty units have just gone up from 1 July to $210, so the maximum fine now is $2.1 million per breach. So the second point there on the slide is the one that we talked about, how long do you have to keep. The step is to destroy or take reasonable steps to de-identify information. I would say putting that beyond use or putting it in a place where it cannot be accessed in error and misused. And basically, because we're going to have to report breaches which are subject to the new rules, we really need to revisit that. So now, okay, someone has just asked me the question, and I will answer it. I didn't have not-for-profits in my survey. What I said is if you're in a corporate, which is any entity that has annual turnover of more than $3 million, you are caught by the APPs, and that does include not-for-profits. So it is based purely on revenue. It includes government departments and it includes not-for-profits. And I have to say that many of the major not-for-profits really struggle with privacy because they often deal with not the individual but their carer or someone who's responsible for them, and they do have a big problem. So what are the reasonable steps that you need to take to ensure security of personal information? Under the Commissioner's guidelines, he sets out a range of headings, which really do mean that IT is a subset. So governance, which includes culture and training, and if you've been listening to anything that APRA has been saying recently, they've pretty much been saying culture comes from the top, so it needs to be part of strategy. It's internal practices and procedures, it's information, communication and technology security, but that's only a part of it. Part of it is access security. Now, you know, many of us will have our swipe cards that give us physical access to various places in our organisations. In many ways, that is just as important. So is access to our systems, you know, what we can get access to. A number of you may remember a big breach in around 2014 where Vodafone in the January holiday period had a number of its records available on the internet. And what they discovered was that they actually didn't have access security that was able to be traced and logged. What they actually had is that in each Vodafone shop, there were a few of these cards, and when a customer came in and had a question, they'd swipe, whether it was a store manager or the casual who worked there a few hours or a week, and they'd see all of their customer history, including their 100-point check documents to deal with what might be a simple query on their account, which did not need access to that whole information. So access security at all levels is really important. Third-party providers is a really important issue as well. Out of the US, you may have heard it referred to as vendor due diligence or vendor management. Our Office of the Australian Information Commissioner has taken the view that just because you subcontract or engage someone else to provide a service to you, you are not losing liability for that. You are responsible for the acts of your subcontractor, so you need to make sure that your contracts with third-party providers deal with privacy to the extent they need to. Data breaches, you need to have a policy. Physical security, you need steps in place. You also need a policy for destruction and de-identification or for moving beyond use. And you also need to, if it's relevant, comply with relevant industry standards. Now, someone has just asked me a question here about the government's protective security policy framework. Yes, if you're in federal government, there are a whole range of standards. If you're in state government, they have a number of standards. And if you're in the general corporate world, out of the US, the NIST, the NIST, the US government standards have recently been adopted by a number of major corporates as being regarded as best practice. So we are moving towards standards around what is acceptable and what is not acceptable. So one of the other things that has happened, I think, in one of the previous cases that the IIA has prosecuted is that the Commissioner has said this does not come without a cost, and it's a cost of doing business, and the fact that something may have cost money to implement is not an excuse for not doing it. That doesn't mean that everyone needs the gold-plated security standards, but it does mean that cost is not an excuse. So that's an issue there. Now, someone has asked a question which I think relates in part to cloud, and I'll refer to that. Someone says, there's a server held in Australia, but information can be accessed from outside of Australia. Do the privacy obligations apply? The answer to that would be yes, because if you are holding personal information in Australia, then you are responsible for the access to that. So if the overseas access is authorised, that's fine. If it's unauthorised, then the Commissioner will consider you responsible for that. It is the way that it is going. In terms of cloud providers, a lot of people ask, well, what does that mean? The Commissioner actually has 275 pages of published guidelines on the APPs and on the various concepts that are contained in those APPs, and those concepts include the concept of hold and the concept of control and the concept of disclose. So it may be that with your service providers, even if they are offshore, you may still control them so that it is not regarded as an offshore disclosure. That's a matter to go back and have a look at. So they're the reasonable steps. So what are our current obligations? Before we get to the new obligations, it's actually really useful to look at what we have now. We actually have some really good guidelines. The OAIC, the Office of the Australian Information Commissioner, has put out a number of publications. in 2014, which set out some guides for what you should do. And he's got some checklists and some guidelines. Oh, I missed a polling question. If we could perhaps open this polling question, because it'd be interesting to know from the people here, if you've suffered a breach in the last 2 years, have you notified affected individuals? Because a lot of my time is spent with people looking at exactly what we're going to look at in the new regime, except we've had the luxury of where we consider that there may not actually be serious harm, then we may choose not to notify. But there's been a lot more leeway in the past than now.
So those poll results are coming in. I've got 5 seconds left. Still need about 100 people to respond to this poll, thanks. Just pop in a response, thanks.
Maybe people don't know whether they've suffered a breach or not because it was so kept confidential within that small group that investigated it, which would not be a surprise.
And here comes the results.
Wow, so 57% did notify individuals. I'm surprised. I think that's high. In my experience, every group of executives say, of course we'd notify it, but then when you actually have that difficult conversation, they try not to. So where are we now? This bill has actually taken 3 hits to get here. If you wanted to say where do we sit with Europe, we're a lower standard, but we're stronger than the voluntary data code. It introduces a new Part 3C to our Act. And, oh my goodness, I went overboard on the polling questions, but I will ask this one now, which is, do you know if you have a breach response plan in place now? And if you don't, and people email me after, I do actually have a model checklist and data breach plan which has a space for everyone's phone numbers, including backup phone numbers, because that's probably the most important thing you need when you become aware of a data breach, which tends to happen, in my experience, out of business hours and often on a Friday. So people go into hyperdrive, into trying to respond.
There's one person that needs to click submit. If you could do that, I can bring up the results instantaneously. Please click submit. There we are, thanks for that. And here comes the results.
Right, so I've got to put my glasses on. So 53% are yes. That means there's a big percent that actually need to get working on that. So let's go through this. First thing we need to work out is when is a data breach an eligible breach? Now, an eligible breach is unauthorised access or disclosure which results in the risk of serious harm. There are exceptions, which include if there's been remedial action preceding that serious harm, and there are a number of types of serious harm that are taken into account. So when we look at all of those, I've gone back. So the first thing to determine is, has there been unauthorised access or disclosure? And that one is fairly simple to work out, yes or no. The next one, which is there a risk of serious harm, is going to be the far more difficult question for organisations to work out. So what are the types of serious harm that you need to consider? You need to actually consider physical, psychological, emotional, financial, and damage to reputation. So that's a fairly big bucket. And one of the reasons that the legislation was passed in February this year but doesn't come into place until February next year is to give the IIA time to put out a number of guidelines and to help business to do this. And in May this year, the IIA put out 4 guidelines, which were drafts, which were open to public comment until, I think, the 14th of July. So they've closed public comment and they'll be issued in final fairly shortly. And they include how do you notify a person and how do you identify an eligible data breach. And they also include some examples of what those might be. So the standard data breaches, the most common one we have, it continues year after year despite all the very sophisticated hacking and the WannaCries. The most common data breach we have is lost devices with unencrypted information on them, such as mobile phones, laptops and tablets. Second most common, working from home and emailing to Gmail, Hotmail or other Yahoo accounts because my remote access doesn't work well. So if you're looking at a policy to beef up at your organisation, that's definitely one that you can look at. So how do you determine whether there's a risk of serious harm? Well, first of all, you look at the kind of information that's been released. You know, does it include date of birth? Does it include driver's license number? Or is it just my name and my business phone number? The sensitivity of the information. Is it subject to any security measures? So is it encrypted? Who could access the information? So when I say one of the issues is it's a lost device, like a lost phone, we'd have to assume that the person who picks up the phone would be a random member of the public, and maybe they're not overly sophisticated, whereas if information was lost in circumstances where it was a deliberate hacking, you might think that the people who'd hacked that information intended to use it for nefarious purposes and had access to other information to actually put it together to cause harm. And you need to look at the nature of the harm that may be suffered. So they're the tests that you need to determine. And once you conduct that assessment and work out whether you think you have an eligible breach, then you have a 30-day period to notify the OAIC and the individual. And I've got there a slide that says multiple entities, because one of the issues is if you have suffered a data breach, is it just you? Is it a number of entities in your corporate group, or is it covering your organisation plus some of your service providers? And if, in fact, you can't determine where that breach occurred as between you and your service provider, how do you and your service provider deal with it? So one of those issues is really important, and I could say from experience that very, very few service agreements contemplate how entities jointly respond to a breach. And that is going to be something that certainly I'm putting in all of the contracts I'm writing or updating for people. It doesn't neatly fit into escalation clauses. It doesn't neatly fit into dispute resolution. And in some of the instances I've had, it's very important because it affects the reputation of all entities who are caught up. So what do you have to do when you notify relevant stakeholders? Well, you have to prepare a statement, and in fact, the Commissioner has got a guideline with, sorry, I'm just reaching across. He's actually got a guideline that says what you should put in the statement. So he's got a guideline about what you need to do. And the law sets out you need to prepare a statement with details of the entities that are affected, a description of the breach, and this might include how it happened, whether it was malicious or whether it was a very simple one, and recommended steps for the individual to take. And this will depend on what types of information it was. So, for example, if you've got an online shop and you think that people's credit card details may have been breached, you would tell them to check with their bank, notify their bank, check their bank statements. If it is just other information and you don't know, or it's not immediately apparent what use that information could be put to. You could just tell them to be aware, or if it was in relation to a certain invoice that they were paying, you can tell them those steps. You also need to give that to the Commissioner, and then how you notify the individuals is one of the issues that the law does talk about. So the new Act says, how do you ordinarily communicate with those affected stakeholders? Do you normally deal with them by email, by text, by letter in the mail? How do you deal with them? You should try and communicate with them in the same modality that you normally use. And if it's impractical, if you can't work out what that class of people is and how you would communicate with them, then one of the best ways to do is to publicise it and put it on your website, which is something that you might do as well. Now, many people would find this quite scary, and we have really good examples of organisations that have done well and organisations that have done badly, and their reputations have been affected, either for the good or for the bad. So thinking back to recent history, if you want to write down an example of someone who dealt with it really well, would be the Australian, the Red Cross and the Blood Bank in Australia earlier this year. They had a data breach of, I'm being told to readjust my webcam, but I'm not able to actually see it at the moment. Let me see if I can. Oh yes, you're right. Sorry, there I am, I'm back. I'm back and I'm in the centre of the screen. Okay, so one of the good recent examples was the Blood Bank, and one of the things that they did, in addition to notifying individuals, they had a call hotline, and they also had a specific website where affected individuals could go and get updates, and they updated it frequently. Now, there was, in contrast to this, there was a situation in New Zealand where an industry association, who I won't name to protect the innocent, had a hack, and they were ready to notify individuals, and they sent out emails to those individuals at about 4 o'clock on a Friday afternoon, and they directed them to a helpline that they could call, but the helpline closed at 5 o'clock on a weekday. So you had a whole group of individuals who found out that their details had been breached. They were notified, and then they had nowhere to go. So they were, as you can imagine, quite unhappy. So how you deal with stakeholders and how you deal with your reputation is really important. The law sets out some minimum steps that you can take, but on that page it is what you need to do. The OAIC, if you go to their website, they do have guidelines, and they will be populating that section of their website more frequently as we go along. And there are examples such as the Blood Bank. But you might say, oh really, do we have to notify everything? Are there any exceptions? There's a couple of exceptions, and I'm just checking how we're going here. There's a couple of exceptions. One is if it would prejudice a law enforcement authority's investigation. And look, some of the breaches that we come across are kept confidential for that reason. There have been a number of scams that people have done with the tax office. So one of the things also when you have a data breach, if you think it's criminal, notify the fraud squad. So go to the police, don't go to your normal police station because they don't know what to do with it. Notify the fraud investigators, they do know what to do, and they might say, we'll handle it from here, and they might also then have advice about how you notify individuals and asking them to keep it confidential so that law enforcement is not breached. Also, if there are secrecy provisions, so in a lot of government contracts there may be secrecy provisions, which would mean that you would need to negotiate with your third parties to determine what exactly you're going to put in that notification. And also, again, the same issue of who is the entity that notifies. And look, if you do have a government contract, you always need to be extremely careful about those provisions because most of them do have secrecy provisions, and if they're not right up front, they're not far away, although sometimes they're buried down the back. So after those exceptions, where is my, come on, all right, okay, so what happens if you don't notify and there is a breach that you should have notified? This is the problem. Consequences of failure mean there's a deemed interference with privacy, and you could be subject to penalties which are up to $2.1 million. So what we are thinking as lawyers is that no one in the organisation will actually be wanting to make the decision about whether it's a reportable breach or not. They'll probably want to outsource that to lawyers or other advisors because no one internally wants to be the bringer of bad news. And in fact, if they say we don't have to notify and then it comes that we did have to notify, people are going to be wanting to sue on the lawyer's insurance policy. And we're quite used to that. So when in your organisation you're faced with people who say, oh, do we really have to? The answer is if we don't, and the Commissioner thinks that it was a notifiable event, then there will be a penalty up to $2.1 million. So I've put at the back here a number of the guidelines that you can, I've missed an O, sorry about that, the OAIC's role in the scheme. A number of the guidelines that are there, they have really useful provisions. The Guide to Developing a Data Breach Response Plan has a checklist on the last page that you can rip off and amend and stick on your wall, but all of this is useful information. I will be asking 2 more questions before we get to the end, and I'll go back to my chat box to see if we have any other questions. Mike, if you could maybe open that poll. It'd be interesting to know how many people here have started an internal project to assess and respond to mandatory data breach. And I would say don't be shy, because if you share the response to this poll, I'll share what I know from other seminars I've been giving. And I think the answer is there's a lot of work to be done in the next 6 months.
So the results are coming in. You've got 10 seconds left. Please pop in a response. Remember, these responses are completely anonymous. And don't forget to click submit. And if you do click submit, then I can pop through the results instantaneously. And click submit. Thank you. And there was one person who didn't. So we've got 20 seconds until the poll results come through.
Okay. I might skip poll 7 because we're running out of time. But irrespective of whether you've started your project or not, one of the issues is, have you engaged external consultants to assist in your planning? Okay, so 33% have started, and you know what? That's about what I'm seeing. A third have started. It's a big task, and what I'm finding is that people are actually starting to, I'm going to skip 7 because we're running out of time. People are starting to engage external people because they do not have sufficient internal resources. So what do you need to do? We need to learn from the Commissioner's decisions. You need to be concerned about insider threats. Humans 1.0 are our biggest risk, but some of you probably know that quite well. We need to think about the cloud. You can deal with it and you can contract around it to protect yourself. You need to start taking steps. A lot of people are looking at cyber security insurance, and the feedback I have is half the people think it works, half the people think that that some of the issues that they'd want to claim on are excluded, so they're not worrying. So one of the issues, what do we need to do from here? Basically prepare a plan, and as I say, if I get people's emails, or I'll email to Ian the mandatory data breach response plan I have if anyone wants it. get external review if you need it. Rehearse your response. Even if you just do desktop analysis, that's good. It's better than nothing. Review the OAIC guidance. Get your external experts on speed dial and look at your insurances. But the biggest thing is start getting a plan, because in every case that I have worked on where people start asking questions, a lot of assumptions that people have made fail to be correct, and there's more work to be done than anyone had to start with. So that brings us to the end. Someone said cyber insurance is essential for any business, and I'd say it's worth looking at, but it's worth reading the policy and looking at the exclusions, because I think cyber insurance has got a bit of a way to go in our market. And then someone else, I've got other questions. If records maintained are found to be inaccurate and not complete and could be misleading, how does this situation resolve? The answer is, look, if you have a breach and there is an improper use of those records that causes some sort of damage to the individual or some perceived damage, then you can be at risk. So that is the issue there. We have another question. If a customer's data has been captured in backup, are we in breach for not de-identifying them? I go back to make sure that your backup is kept beyond use so that it can't be hacked. Someone else has asked, what would you deem adequate insurance coverage for data breach, because the penalty is $2.1 million. The penalty is $2.1 million per breach, and that's the fine. That doesn't include your cost of remediating and any reputational damage you might have to fix. So quite frankly, the risks are higher and the costs can be higher, which actually makes giving a little bit of budget to preparation a good use of resources. I'm thinking that I've picked up all the questions. I'm thinking...
I think you have. I don't think you've missed any questions. I've been keeping an eye on the chat, so I think you're good there.
Well, I think unless there are any other questions, I think we've got that covered. All right.
Thanks for that, Lynn. I'm just going to pass back to Ian. Ian, are you there? I'll get you to toggle on your webcam, thanks.
Cool. Oh,
there you go. And I'll get you to toggle on your webcam, Ian, thanks. It's not on at the moment.
Oh, I can see myself on my webcam. Can you?
No.
Oh, let me try again.
There you are. Oh, you've gone.
I just switched myself up again. We're having a bit of technology issues here. I think you can see two of us now. Is that right?
Yes.
Yep. Okay, great. Okay, thanks, Lynn, very much for a really informative session. Thanks for taking the time out today. We've actually already organized our next webinar titled Cyber Resilience, Is your online frontline secure? By Stephen Coates on Tuesday the 14th of August. And you can register through the IIA-Australia website under webinars from Wednesday this week. Please check out our web flyers and our website for our remaining short courses in 2017. And if your organization has any particular training needs and would like to schedule in-house training, please contact me. So to exit this webinar, please click on the X at the top right of your screen and you'll be redirected to a feedback form, which will take about 30 seconds for you to fill in, and it would be give us really valuable feedback for our webinars in the future. Thanks again, everyone, and I hope you can participate in our webinar next month. Enjoy the rest of your day.